Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. Last week, the Department of Labor celebrated the new year with 6 new opinion letters. Today, we're running down what they said. 4 of the 6 letters dealt with the application of federal labor standards under the Fair Labor Standards Act. In these letters, the DOL clarified that certain bonuses must be included when calculating overtime. Employers may reclassify exempt employees as non-exempt. Retail and service establishment employers must use the federal minimum wage rather than the state or local rate when determining whether certain commissioned earning employees meet exemption criteria. And a pre-shift roll call must be treated as hours worked, but may potentially be excluded from overtime calculations. Epstein Becker Green's Genevieve Murphy-Braddox is here to tell us what the DOL had to say about FMLA standards.
In Opinion FMLA 2026-1, the DOL was asked to opine on how a school closure of less than 1 week due to inclement weather impacts the amount of leave a school employee uses under the FMLA. In its opinion letter, the DOL clarifies that when a school closes for part of a week, during which an employee was approved to take FMLA leave for less than a full work week, the period during which the school is closed and the employee is not required to report for duty is not counted as FMLA leave. Conversely, when a school closes for part of a week, during which an employee is using a full week of FMLA leave, the entire week may be counted as FMLA leave.
In another opinion letter, the DOL said that FMLA leave may be used for time spent traveling to or from medical appointments, even if the medical certification does not specifically address travel to or from the appointments. Genevieve, what can employers take away from this opinion?
A medical certification should not be deemed incomplete simply because it does not include information addressing travel time, nor should employers seek additional information from the healthcare provider regarding travel time. Similarly, requests for intermittent or reduced schedule FMLA leave to attend medical appointments should not be denied solely because the amount of time requested by the employee does not precisely match the anticipated duration of the medical appointment specified in the medical certification.
That's where things stand on the federal level. But more than half the country is subject to state and/or local laws that go beyond the federal statute, with some jurisdictions making paid family and medical leave benefits available. What are the states doing in terms of paid family and medical leave regulation?
13 states and the District of Columbia offer paid family and medical leave programs. Several of these programs are making leave benefits available to employees for the first time in 2026, while others have been amended over the last several years to expand the availability of leave and leave insurance benefits for a growing list of qualifying reasons, many of which are far broader than the qualifying reasons under the FMLA. A number of other states offer voluntary opt-in paid family medical leave programs. Now, more than ever, it's critical for employers to understand how these mini family and medical leave laws interact with leave under the FMLA, as well as other leave programs that may be offered by an employer or are statutorily mandated, such as earned sick leave under a state and local sick leave law. To help make compliance easier, we have created a resource guide map that highlights the patchwork of mini family and medical leave laws across the U.S.
Thanks, Genevieve. For more details on state FMLA regulation, you can check out the map at ebglaw.com/mini-FML. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.